Welcome. No, I am not the Chancellor. Chancellor Severard has agreed to graciously introduce our speaker today, but some events have unfolded that prevent him from being here, and we're all delighted that he can't be here. I think you'll share in our joy, go Orange, that he is joining the women's basketball team tonight as they, move to victory on the courts of wherever they are at the moment, I'm sorry. So he really expresses his apologies, and I will stand in hardly in his shoes, but I have the honor now of introducing our guest speaker. So welcome. I'm sorry that he couldn't be here, and so is he. It really gives me great pleasure to introduce Professor Sam Bagenstos today to the College of Law. We're celebrating, and he's helping us celebrate, the 10th anniversary of the Disability Law and Policy Program, which was founded to bring together the various disability academic programs, courses, activities, co-curricular activities here at the College of Law. And for the past 10 years, I've been privileged to teach an amazing group of students, many of whom are here today. We've developed together joint degrees with the School of Education and the School of Social Work. We have a curricular program in disability law and policy, an extraordinary group of students literally from all over the world who now come to us to study disability law in our LLM program. We have our esteemed Disability Rights Clinic, directed by Professor Michael Schwartz, who also apologizes that he can't be here today, as well as an active disability law society. But our success is really due in large part not just by what we do here in this building or in our former building, but rather in our collaborations across campus. And certainly that's one of the reasons that many of us have chosen to stay or to come here to the College of Law. And I'm fortunate to say that a lot of what we do here we couldn't have done, or maybe we wouldn't want it to have done, without collaborators and colleagues and students and faculty from other schools like the College of Arts and Sciences, Fall College, the Honors Program, the School of Education, Maxwell, Architecture School, and on and on. And all of them are also co-sponsoring this lecture series, so we thank them. We also want to thank other co-sponsors like the Disability Law Society, which I have to say under Dan Van Sant's leadership this year has, I think, broken all records in terms of activities and energy and commitment. Thank the Beyond Compliance Coordinating Committee, which is our graduate student organization throughout the university, the Disability Cultural Center, which is really a model around the world, as well as the Cultural Foundations of Education program in the School of Ed, the Women and Gender Studies Department, and the Office of Equal Opportunity Inclusion, Office of Equal Opportunity Inclusion Resolution Services, and our new director, Aaron Hadukovich, for supporting our CART and our sign language interpreters. So thank you also, sign language interpreters, for being here today. A special thank you also goes to Joel Whitney back there, and Chris Ramsdale, and Bob Conrad. And most of all, I also want to thank our interim dean, William Banks, who is acting as our dean this year and I think has really moved the law school and created for all of us this year a feeling of energy, support, and commitment to the role of public law in legal education. So thank you, Dean Banks. Okay, how are we doing? Okay, let's move to our speaker. Professor Bagenstos is the Frank G. Millard Professor of Law. He specializes in constitutional law, civil rights, and disability law. From 2009 to 11, he was at the U.S. Department of Justice, where he served as the Principal Deputy Assistant General for Civil Rights. There he worked on the promulgation of the 210 Americans with Disabilities Act regulations, as well as increased enforcement of the U.S. Supreme Court's decision in Olmstead versus L.C. That case guarantees the right of people with disabilities to live in the community and receive services in the most integrated setting appropriate, which means like people without disabilities. He led negotiations in several Olmstead settlements that guarantee appropriate community-based services to thousands of people with disabilities nationwide. And all this he did while he was arguing major cases in federal district courts and court of appeals across the country. Professor Bagenstos frequently consults with civil rights organizations and remains an active appellate and Supreme Court litigator in civil rights and federalism cases. I'm hoping that maybe today he'll discuss some of these cases, including a recent case filed on March 31st, could we have it more timely, by him and the Disability Rights of Ohio and the Center for Public Representation against the state of Ohio for its failure to release people into the community from institutions, alleging violations of the Americans with Disabilities Act and the Supreme Court's decision in Olmstead. Professor Bagenstos has argued 3 cases before the Supreme Court, including Young versus United Parcel Service, which established new protections for pregnant women, United States versus Georgia, which upheld the constitutionality of, anyone in my class remember, Title II of the ADA? And he's testified before Congress on several occasions, including support for the Fair Pay Restoration Act, the ADA Amendments Act, the Employment Non-Discrimination Act, and the Convention on the Elimination of Discrimination Against all forms of discrimination against women. He also has worked on the issue of the ADA and technology and problems of people with mental disabilities in prisons. By the way, he's also an accomplished scholar. He's published articles in lead journals and a book entitled Law and Contradictions of the Disability Rights Movement, in which he provides a particularly insightful look, in my view, on the accomplishments as well as the challenges and shortcomings of the disability rights movement. He's also published in non-academic journals. I've been doing my reading lately, and one of them, in the New Republic, caught my eye, which I thought you nailed it here. And that involved not a disability case, but the case of Kim Davis, the clerk in the Kentucky marriage license issue, who refused to issue marriage licenses to same-sex couples. Sam wrote in this piece that the court was wrong in ordering her in contempt and to jail. He pointed out that instead, if and when people don't do their job, or if and when kids don't obey the rules, right, they have a penalty. She could have been fired. Or in this case, if she chose not to carry out her constitutional obligation to issue marriage license on an equal basis, she could have been forbidden to issue marriage licenses at all, and the court could have ordered, under state law, that she wouldn't have received that portion of her salary, which was being paid for her to do part of her job. And they could have used that money to reimburse the people who did it. So this article, and I really encourage you to read everything he's written, but this article, as well as all of Sam's writings and advocacy, in my view, shows not only his willingness to take on controversial and important social issues, but also a command of the law, careful critical thinking, and strategic reasoning that is necessary to persuade in this day and age. To me, he exemplifies the best in the legal academy, one who uses his intellect and passion for the public good. Prior to joining the law faculty, he was a professor, associate dean at Washington University School of Law, where he worked with our chancellor, and he's also taught at Harvard Law School, UCLA. He's worked as a law clerk in the Ninth Circuit, and by the way, he was also a law clerk to Justice Ginsburg on the U.S. Supreme Court. So we're just delighted that he's here today. We're not going to talk about, well, I guess we did talk briefly, that we have now also more in common than we knew a week ago. And that is that Sam is also a graduate of North Carolina for his undergraduate years. And, sorry, well, it's okay. It's okay. It turned out okay for you, I guess, for others. And a graduate of Harvard Law School. So thank you very much for being here today, Sam. We look forward to hearing from you.
Thank you. Thanks very much. Yeah, I am deeply embarrassed by that introduction, and not by the notation that I attended the University of North Carolina, which I'm very proud to have done. And, you know, at least you can feel like the Big East prevailed, and I still think of Syracuse as a Big East school, as I think your men's basketball coach still does as well. So I was upset. I was a little upset that Kent Syverud couldn't be here to introduce me today, because, you know, Kent and I do go back to our time together at Washington University. I felt a little better about it because I realized he would have lots of embarrassing things to say about me, embarrassing private information that he might share. But then now I feel worse because you've now heard an introduction I can't possibly live up to. But I want to thank all of you for coming. 5 o'clock on a Tuesday night is not necessarily everyone's favorite time to come to a lecture. I want to thank Arlene for inviting me. This is just really a terrific program you guys have here. Both in the law school and at the university in general. I mean, this is one of the epicenters of thinking about disability and disability issues from a whole bunch of different perspectives in really interesting ways. Basically, everything interesting that's been written about disability in the United States over the past decades at some point or another found its way through here, either came from here or was amplified here, was very importantly developed here. And so it's a real honor for me to be here to talk about this stuff. So Arlene talked about many things that I do. I am a person who gets bored. I do many different kinds of things. I'm going to talk about only a slice of that, although if you want to come up to me afterwards and talk to me about Kim Davis and the articles about Kim Davis and the HBO miniseries Show Me a Hero, and when we could talk about that a little bit if you want afterwards. But what I wanted to talk about, just taking the opportunity of a couple of anniversaries. I wanted to talk about a project on the politics of disability identity. And what are the couple of anniversaries? Well, one is the anniversary that led me to being invited here, and so many terrific speakers to being invited here this year, which is the anniversary of your disability law program. And the other is the 25th anniversary last year of the ADA. So the ADA was adopted in 1990, in July of 1990, and so last summer it experienced its 25th birthday. I have had the remarkable privilege over the course of my legal career to basically spend my legal career with the ADA as it grows up, from its childhood when, as a lawyer at the Justice Department in the early and mid-1990s, I worked on a lot of the early cases on the ADA, through its adolescence, which didn't go so well, and we had to have an intervention from Congress to kind of get it back on the right path, and now through its adulthood, which I think things are looking up. And so that's sort of what I want to talk about. And so I've titled the lecture, The Politics of Disability Identity at ADA Plus 25. So 25 and a half, we're 25 years since the ADA was adopted. And what I want to talk about is what we've learned about the project of creating a disability identity and destigmatizing a disability identity and normalizing a disability identity over the course of the last 25 years. So let me just say this. So one way of looking at the disability rights movement in America is to look at the particular effort that the disability rights movement in America made really over the last 50 years to forge a pan-disability identity. It's not the only project of the disability rights movement, but it's an important one, an important strand. In a lot of my scholarship, including the book that Arlene talks about, I have argued that the development of a collective disability identity played a key role both in mobilizing people to participate in the disability rights movement and as serving as a focal point for the disability rights movement in America. Before people with conditions such as paralysis, blindness, deafness, mental illness, developmental disabilities, epilepsy, diabetes, HIV, cancer, and other conditions could succeed in obtaining comprehensive civil rights protections, people with each of these conditions had to understand themselves as being part of not separate groups, but the same group. And so developing a pan-disability identity was an important and explicit focus of a lot of American disability rights activists, particularly during the period in the 1970s and 1980s leading up to the adoption of the ADA. This effort was a kind of departicularizing effort, right? It was an effort to move understandings of identity away from narrow diagnosis-based or condition-based groups to the broader group of people with disabilities in general, and it was a group that, at least at the time the ADA was adopted, Congress said was 43 million Americans, a number that haunted the case law for a while before Congress struck it from the federal statute books. So it was a move toward universalization, but it was not completely universalizing, right? The idea was to go from all these little groups to one big group, and it was a really big group. But it was a big group that remained separate from the rest of society. The idea of developing a disability identity presupposed a line between people with and people without disabilities. And the question of who was included and who was excluded by that line was a question that was highly contested, both by groups whose members didn't want to be included in the disability category and by people outside of particular groups who didn't want those groups to be included in the disability category. And it's a line that remains contested today, although it's contested in different ways. And I think there are some recent changes that suggest that maybe the process of universalizing disability identity is moving along very nicely. So what I want to do in this lecture is I want to focus on the contestation over this disability versus non-disability line, both in the period leading up to the enactment of the ADA in 1990 and in the 25 plus years since then. And in particular, the argument's going to be that many groups that had previously sought exclusions from the disability category, groups that had wanted not to be in the disability category, are now showing increasing affinities with the category of people with disabilities. And this is, I think, an indication that another crucial goal of disability rights supporters, to normalize disability, to destigmatize disability, is increasingly being achieved. So I usually tell sad stories. Okay, this is I mean, if you read my book that Arlene talked about, I mostly say everything is terrible in the world, nothing is ever getting better. This is a positive story for me. So don't attack me too much for it, or I'll have to return to being very negative all the time, and no one will like that. No, attack me all you want. I kind of like that, but I actually, it's a rare moment when I'm feeling sort of hopeful, a little bit hopeful. So let me talk in a few stages about this. The first stage is to talk about the effort to forge a pan-disability identity pre-ADA. So you could start the history of disability in this country in all kinds of places. Let me start in a particular place. So the category that we call disability didn't become a central organizing concept for advocacy until the 1970s. Now, you know, there's disability, there's Social Security disability, there's disability insurance, disability pension. Disability as a concept there, which predates the 1970s, is really a concept about inability to work. It's about exclusion from the obligation to work. But as an organizing concept for a social movement, the concept of disability, we don't really get until the 1970s. But before then, we always had, for a long time, physical and mental conditions that led people with those conditions, because of attitudes in society and because of the way society has been arranged, to be treated as abnormal and devalued. And by the middle of the 20th century, there was a very strongly articulated and held medical model of understanding disability in this sense. I mean, we talk about medical model and disability in lots of different ways. This is what I mean in this context. Doctors and other medical professionals were the authorities on these conditions. They were the people who made the diagnoses that led individuals to be treated as members of abnormal and devalued categories. And individual and societal efforts focused on identifying and providing cures for these conditions if possible, and care, welfare, or charity if not. Because that medical model placed so much emphasis on medical professionals' diagnoses, those diagnoses became, I would submit, the central organizing principle of what today we would kind of ahistorically call disability advocacy. So advocates for people with disabling conditions, and the four is really important. These were advocates who rarely had those conditions themselves. Advocates for people with disabling conditions pressed for research funding or care and treatment on a condition-by-condition basis. Different medical diagnoses had their own advocacy groups, their own research programs, their own institutions. Remember, these are the days of very heavy institutionalization in America. Even their own telethons, right? I was talking about telethons to my employment discrimination class today, and these kids in their 20s, they just don't have much experience with telethons. This was like the thing that was on, that occupied the public space about disability until very recently, was, you know, fundraising telethons for particular diseases and for particular diagnosis defined groups. And early precursors of the disability rights movement, even folks who were fighting for rights, largely followed these diagnosis-based lines. So you have the League of the Physically Handicapped in the New Deal period arguing for inclusion in New Deal work programs, basically about people with particular kinds of physical disabilities. The National Federation of the Blind, the longest running, continuously operating organization made up of, led by, and advocating for people with disabilities was made up of, led by, and advocating for people who were blind. In the 1960s and the 1970s, as we started to get some of the other disability advocacy organizations turning toward rights and away from care and cure and research, those also were groups that focused on particular diagnoses. So exemplary here is the ARC, what was known at the time as the Association for Retarded Children, or then Citizens, and then eventually the ARC, as we got rid of the word in the middle of the acronym. Again, focusing on particular conditions. The particular diagnosis remained the dominant organizing principle. In the 60s and 70s, though, as Americans with disabilities developed a much deeper rights consciousness, things began to change. Civil rights advocates began haltingly to see disability as a civil rights issue, civil rights advocates outside of the disability community. And why did people with disabilities start to see issues as civil rights, and civil rights advocates start to see disability as a civil rights issue? Well, there are a lot of causes. Everybody can probably tell their own story. I mean, to me, the biggest causes are, first, obviously, the effect of the African-American civil rights movement and the women's movement. I actually think the ideological connections between the women's movement and the American disability rights movement are very strong. Also, the number of veterans returning from Vietnam with disabilities who are infused by the rights consciousness of the time and are kind of ticked off about how they were treated both in being sent to Vietnam and when they returned. And a central part for them, for all these groups, of reframing disability from an issue of medicine or charity to an issue of rights was to see the exclusion of disabled people from civic and economic life as a form of discrimination, whether intentional discrimination or what disability rights advocates consider to be the same thing, the failure to take account of people with disabilities when designing our social structures, when designing our physical structures, when thinking about how we're going to do things in society. And because issues of discrimination or the failure to accommodate link together the entire range of diagnosis-specific groups, advocates began to conceive of all these groups as sharing a crucial identity, the identity of handicap or disability. And that idea of pan-disability identity had benefits in pulling together a social movement to push for legal and social change, but also in focusing that movement on a particular goal, which was, at least as a lawyer I think of, a comprehensive disability civil rights law. So that law was the ADA. So there's this effort in the period leading up to the ADA, in the 20 years leading up to the ADA, to reframe disability from a bunch of different things to one thing, to a single identity. And this played a significant role, not the only thing that played a role, but it played a significant role in the effort to get the ADA passed. Now, this leads me to the second stage of this lecture, which is the efforts of some groups, both themselves and from people outside of those groups, to keep particular groups out of the disability category. So the campaign to enact the ADA provided a focal point for activist efforts to create a unified disability identity, and at the same time that campaign benefited from the increasing recognition among disabled people themselves of a disability identity. And I have a quote here from the journalist Joe Shapiro, who wrote this terrific book, No Pity, about that sort of right after the ADA gets passed, and it's kind of the in-the-moment first draft of history chronicle of the ADA campaign. And so he says, the ADA brought this fragmented population together in a fight against discrimination. And then there's this quote from my good friend Liz Savage, who is like one of the leading lobbyists for the ADA, who says, people with epilepsy now will be advocates for the same piece of legislation as people who are deaf. That's never happened before. That's really historic. And then back to Shapiro, there were 180 national organizations that endorsed the bill, from large charities like the National Multiple Sclerosis Society and the American Diabetes Association to smaller ones like the National Ostomy Association, the Association for Persons with Severe Handicaps, and the International Ventilator Users Network. There were groups representing all the major disabilities, including spinal cord injuries, deafness, visual handicaps, mental retardation, mental illness, as well as those for newer or less well-known conditions such as AIDS, right? Giving you the sense of, and it's just a slice, of all the many different condition or diagnosis-based groups that came together. But not everything that triggered discrimination or demanded accommodation was included in the disability category. And there were substantial fights about where the line should be drawn. Some of the opposition to including particular groups came from people who were not members of those groups, right? So people with HIV and sexual minorities are examples. But much of the opposition, and this is in some ways more interesting, came from members of those groups themselves. These group members thought that their inclusion in the disability category would not fit and would in fact be harmful to them. So they didn't think that their conditions fit an understanding of disability. And important organized groups of people who were deaf or blind felt this way at various points, though the ADA ultimately included those conditions. And both members of the LGBT community and women's rights activists had consistently argued against treating sexual orientation, gender identity, or pregnancy as disabilities. And in the end, these conditions were basically excluded from ADA coverage. So let me talk about various of these issues. Let me start with HIV. So enactment of the ADA came at the height of the AIDS crisis. In 1990, when the ADA was adopted, around 30,000 Americans died of AIDS, just in that year alone, making a total of about 120,000 since the disease had been identified earlier in the decade, or early in the 1980s. And there was a lot of discrimination against people with HIV and AIDS in the 1980s. Many examples of discrimination throughout the country in the workplace when people showed up at work with conditions that indicated that they had AIDS, they would often get fired. Kids at school who had HIV would often get segregated or excluded from school. Widespread discrimination because of widespread hysteria about HIV and AIDS. And the ACLU, both nationally and around the country, and gay rights organizations spent a lot of time fighting these battles on a workplace-by-workplace or school-by-school basis. But they also committed that what they should do is focus on getting a law enacted to prohibit discrimination against people with HIV around the country. Now, that quickly morphed into a piece of the campaign to pass the ADA. So what started out for a lot of folks in the HIV/AIDS community as an effort to get a specific law passed ended up becoming a significant part of the campaign to pass this very comprehensive law. Why was this? Well, a few reasons. One, people with AIDS and HIV were already succeeding under disability laws in court. The prior disability laws, the Rehabilitation Act of 1973, particularly in the schools context, provided substantial tools for challenging HIV-based discrimination. The Arline case decided by the Supreme Court in 1987, a case about tuberculosis, but it wasn't really about tuberculosis, and nobody thought it was really about tuberculosis. The Supreme Court said you can't discriminate against a teacher based on contagion unless that teacher poses a direct threat of passing the disease on to other people. Justice Brennan, when he announced the decision in court, had to say, this isn't in the opinion, this is just in his announcement, he said, by the way, this case isn't about AIDS, which was the tell that it was totally about AIDS. Everybody knew that that's what the case was about. It wasn't about teachers passing on tuberculosis. And the text of the ADA, as framed, as copying from the Rehabilitation Act, seemed to cover AIDS. And both within and outside of the federal government, advocates like C. Everett Koop inside the federal government, advocates like Admiral Watkins, who headed President Reagan's AIDS Commission inside the federal government, but also advocates in the ACLU outside the federal government begin to coalesce around the idea that the ADA can be the vehicle they're looking for to challenge HIV-based discrimination. This leads to efforts by folks who oppose the ADA, who oppose rights for people with HIV, and who oppose gay rights in general. It triggers a challenge from them. So some quotes here, Dan Burton, Congressman Dan Burton, famous later on for running a series of inquiries into the Whitewater scandal in the Bill Clinton years, Among other things, he believed that Vince Foster, the associate White House counsel who killed himself, actually had been murdered, and Dan Burton did various things like construct a new crime scene in his backyard in which he shot a pumpkin, which the pumpkin stood in for Vince Foster's head, whatever. Dan Burton, also very much opposed to providing rights for people with HIV and AIDS, so he says, the ADA is the last-ditch attempt of the remorseless sodomy lobby, that's what he said, to achieve its national agenda before the impending decimation of AIDS destroys its political clout. Their bill simply must be stopped. There will be no second chance for normal America if the ADA is passed. So using the coverage of HIV as a way to challenge the ADA itself. Bill Dannemeyer, Republican congressman from Orange County, California, classic Orange County Republican, says, with this bill, in the form that it's now to be considered by the House, if it is adopted, every HIV carrier in the country immediately comes within the definition of a disabled person. Is that sound public policy? And since 70% of those persons in this country are HIV carriers are male homosexuals, we're going to witness an attempt or an utterance on the part of the homosexual community that when this bill is passed, it will be identified by the homosexual community as their Bill of Rights. So 1990 is very different from 2016 on these issues, right? Can you imagine anybody even saying that today, right? Even if they believe it, they wouldn't say it today. But this, well, okay, fair enough. But this was the argument that was being used to take down the ADA. And there, one of the efforts that is used, one of the efforts that's employed is also to try to split out people with HIV from the coverage of the ADA, right? So there's a series of amendments in Congress. Congressman Chapman from Texas proposes an amendment that says anyone with HIV can be excluded from food handling positions. The disability community comes together and says, no, we're opposing this amendment. We are not going to exclude people with HIV from the coverage of the ADA, even in jobs that involve handling food. Instead, this becomes an amendment that gets drafted by Orrin Hatch, which actually requires a study of what kinds of diseases are unsafe for handling food, which everybody understands is going to lead not to the exclusion of people with HIV. So this is an example of people with HIV using the vehicle of the ADA to be included within the disability concept, the disability category, efforts on the outside to exclude them, and the disability community, the broader disability community coming together and saying, no, actually we want people with HIV included with us. And so that stays together. The Bragdon case in the Supreme Court in 1998 says asymptomatic HIV is often a disability and covered by the ADA. The ADA Amendments Act in 2008 makes clear that HIV is basically always a disability. Okay, so that's HIV. Deafness. Let's talk about deafness. So deafness, what's the controversy there? Everybody knows deafness is covered by the ADA. Well, true enough, right? Always has been. But there's an interesting backstory to it, right? Which is many deaf people, capital D deaf people, culturally deaf people, traditionally thought of themselves as not really being the same as people with other kinds of physical or sensory disabilities. The distinctive trait is we use sign language rather than there's some physical limitation. Sign language isn't just a different way of expressing English, right? Sign language is a different language. So the distinctive trait is being a member of a linguistic minority that maybe should have rights like Québécois have in Canada. Also, for many deaf Americans, there's a history of separate schools, which were focal points for community building, and were threatened by the integrationist thrust of a comprehensive disability civil rights law. So there was tension. Now, the tension never erupted into efforts to exclude deaf people from the ADA, in part because the protests of deaf people at Gallaudet University in 1988 become such a focal point for the broader disability rights movement. And, of course, the ADA ends up doing a lot to protect deaf people, and in the end, no deaf group opposed the ADA or even failed to support the ADA. Blind groups were a different matter. So you have a very substantial division within the blind community. Many different groups representing people who are blind, people who have other vision disabilities. The oldest one, though, is the National Federation of the Blind. The National Federation of the Blind, although a big supporter of the ADA today, was not a supporter of the ADA as it went through Congress. In fact, withheld support from the ADA as it went through Congress. Why? It's a bit of a puzzle. The ADA, the NFB's founder, one of its founders, Jacobus Tenbrook, wrote the crucial articles in the California Law Review in 1965 that provided the template for disability law in America, right? If you're looking for where American disability law comes from, it comes from Tenbrook. But the NFB had done very well for itself and its members for years by pushing laws of interest to the blind community particularly laws like white cane laws, which were an early form of disability accommodation law that did things like require cars to stop for people using white canes who were crossing the street. And there was some concern among folks within NFB about tying blind people who were easily seen in society because of the efforts of NFB through the years as independent, as not really that different from non-disabled people, about tying blind people to people with other more involved conditions that it might be harder to tell a story of independence with. There was also some concern about particular ADA requirements. Integration remained an issue, but also requirements like curb cuts, which interfered with the way that blind people went through the world independently, right, until eventually this gets worked out. Now, in the end, blind people weren't carved out of the ADA. Many blind groups supported the ADA. How could you have excluded blind people from a statute that protects people with disabilities against discrimination? And the NFB, along with other blind groups now, makes aggressive use of the ADA to promote all sorts of ends. The ADA has become a crucial tool for NFB in particular in making information technology and the web much more accessible. And NFB has been a very aggressive litigant. But all through the process of getting the ADA enacted, there was this standoffish attitude.
I've never forgiven them.
And so it's an interesting question. How one ought to think.
I belong to their rival group.
Yes, so there you go. And the tensions remain today. The tensions remain today over particular cases, and we could talk about that for a long time, but there's this effort, at least among some folks, to say we're not part of this general disability group. All right, so let me talk about, see how long I've been talking for. Let me talk about LGBT groups. So for a lot of the history of the LGBT movement activists focused on getting removed from the disability category, right? The goal was not to be treated as disabled. There was a history in America of treating gays and lesbians, not to mention transgender individuals, as experiencing a mental illness. If you look at the first two editions of the DSM, the Psychiatric Bible of Diagnosis, right, they listed homosexuality as a mental illness. Yes, until 1973, and it's removed in 1973 because of the efforts of the young gay rights movement in America, right? And it's not really removed totally in 1973, right? So it gets changed to this idea that homosexuality is no longer a mental illness, but something called ego-dystonic homosexuality remains a mental illness. What does that mean? That means if you're gay and don't feel good about it, basically. And gay rights activists think this is incredibly demeaning too, and continue to push. And so finally, in 1987, it's removed entirely, right? So 1987, 3 years before the ADA gets adopted, 1 year before the ADA gets introduced in Congress. And so we have this history fresh in mind. Now, the history leads a lot of folks who are opposing the ADA and who are trying to throw up examples of stigmatized conditions that the ADA will cover to say, well, now the ADA is going to cover people who are gay just for being gay, using all the same kind of homophobic language that Dan Burton and Bill Dannemeyer used that I cited before. They include in the statute a limitation, an exclusion of people with various conditions from the definition of disability. I'll just read it to you. So the exclusion says, A, homosexuality and bisexuality. For purposes of the definition of disability, homosexuality and bisexuality are not impairments and as such are not disabilities under this chapter. And then it says subsection B, certain conditions. Under this chapter, the term disability shall not include transvestitism, transsexualism, pedophilia, exhibitionism, voyeurism, gender identity disorders not resulting from physical impairments or other sexual behavior disorders, also compulsive gambling, kleptomania or pyromania, and then current illegal use of drugs, which was a whole other issue. So this resulted from right-wing pressure, from the pressure of folks like Dannemeyer, like Burton. As the quotes above, the quotes I've already read you show, the effort to exclude people with HIV, just like the effort to exclude gay people, was driven by anti-gay feelings, was driven by homophobia. But here, unlike with HIV, there's no significant pushback. So the folks who are pushing the ADA don't push back. Gay rights groups don't push back. They want to include HIV in the ADA. They're not pushing to include being gay as a disability or being a person or being a transgender person as a disability. And why is that? Well, in part, I think it's the cognitive dissonance of having spent so much time and effort for nearly 20 years to get being gay out of the disability category, and then now trying to include it. In part because it's still a very homophobic world, right? Part of what's going on is it was hard to believe in 1988, 89, 90 that Congress would pass a law protecting gay people against discrimination in the workplace or in school. And, Congress still hasn't passed a law that explicitly does that. But you have, compared HIV to LGBT issues generally, you have the exclusion fought away in HIV, and the exclusion just gets included without significant pushback. Okay, finally, one other example, which is pregnancy. So, as with sexual orientation, nobody thought that ordinary pregnancies were covered by the ADA. Maybe you could be pregnant and pregnancy could lead to a disability if there was a particular complication, but nobody thought pregnancy was a disability covered by the ADA. Even though pregnancy is something that there are lots of misinteractions between pregnancy and workplace rules, just like between various physical or mental conditions and workplace rules. And accommodation might be an appropriate response to that, just like in the context of disability generally, but no one thought pregnancy is covered. In part, this is because of, just like in the LGBT example, feminist efforts to distance pregnancy from disability. So you see a history in America of women's capacity to become pregnant being treated as something that is a disability, something that makes women less able to do various things in society. I could give you lots of quotes on this too, but I think I won't. But you've probably heard them, right? So all you have to do is read the brief that Louis Brandeis wrote in Mueller versus Oregon, which is often treated as this great progressive step because it got maximum hours laws for women upheld. But if you read it today, it's the most sexist thing you've ever seen, actually. It's full of assertions that women are less capable than men of doing all sorts of things. And all of the metaphors are disability metaphors in the brief. And that happened for years, for decades. Many feminist lawyers in the 1970s, including people like Ruth Bader Ginsburg, opposed pregnancy leave policies policies of pregnancy accommodation, precisely because they thought that pregnancy accommodation policies would send the message that pregnant women were less able and would encourage discrimination against women on the grounds that they might potentially become pregnant. Right? Again, a concern that they didn't want pregnancy to be thought of as disability. And in the end, pregnancy isn't included, although you see a lot of commentary around at the time saying, well, why isn't it? Okay, so that's sort of the second stage of this. The third stage is, well, what was at stake here? So these are interesting stories. I like telling the stories. But what was at stake was an understanding of what disability was. So everybody at the time acknowledged that the previous understanding of disability, the understanding of disability that they were responding to, was disability as a lack, as a deficit, as a problem. There's something wrong with you. There's something about you that's missing if you have a disability. Now, that may be a lack or a problem that is deserving of charitable or pitiful treatment, but, beneficent treatment. But it's a problem. Its disability is something negative. That's the view of disability that advocates of the ADA were responding to. You could respond to this problem, this view of disability, in two different ways, with two different kinds of politics. So one is a politics of distinction, and one is a politics of universalism. So if you are advocating for, if you are a member of a disability group in 1990 and trying to respond to this view of disability, you could say, politics of distinction, well, if you look at my group of people, we're not really disabled like all those other folks. Right? So I call this politics of distinction. I take the phrase from Randy Kennedy, the Harvard law professor who's written a lot about race in the criminal justice system, and says, we have to, it's sort of a version of respectability politics, that we have to draw a distinction between law-abiding African Americans and non-law-abiding African Americans. He's African American himself, and making the case that it's important for our policy to recognize those distinctions. And you could easily see that same policy, that same politics here. And NFB's view is a little bit like that. It's a little bit driven by the politics of distinction. Politics of universalism is to say, let's unpack what this thing disability is. What's this thing disability? And this gets filtered through what people start to talk about as the social model. This thing disability actually is about a mismatch in interaction between a person and that person's qualities and the social situation, physical structures or social structures that person deals with. And once you think about disability that way, you could say, well, actually, everybody has mismatches between something about them and something about the social structure, institutional structure, or physical structures they deal with, right? And that would be the politics of universalism. ADA advocates took largely a universalist strategy, right? As I said, it's universalizing, if not fully universalist. So first, by fitting disability into the framework of prior anti-discrimination laws, by treating the failure to accommodate disability as a kind of discrimination, both definitionally and in terms of the way it was justified, right? So how did people talk about why do we have an accommodation requirement? Well, it's not because disabled people are so bad off that they need redistribution in the form of accommodation. It's that, gosh, when you're designing a building, you think about the people who are going to be the normal users of the building, and you design the building for them. And if you designed a building in a way that excludes people who use wheelchairs, that means you were treating those people unequally. You weren't treating them as full members of the community, as expected users, and therefore you were discriminating against them. And you can ramify that insight in various ways, as I'm sure people in this room have done. So one piece of universalizing is treating disability as a problem of discrimination and disability accommodation as a problem of discrimination. The other universalizing aspect of the ADA is that the people who drafted the ADA adopted what they understood to be a very broad definition of disability. Now, courts didn't read it that way, but they thought, if you ask the people who wrote this, and I think they're being entirely truthful, they thought they were writing a definition that would encompass an enormous number of people. way more than 43 million people, the 43 million people they listed in the statutory text. They thought basically almost anyone who was discriminated against because of an actual or perceived physical or mental condition would be covered. And they pursued a universalizing strategy by fighting against amendments like the amendment to exclude HIV, various other amendments to exclude other stigmatized disability. There were a whole bunch of them. So this was the sort of the strategy in the Senate where you can just propose amendment after amendment after amendment. You had Senator Armstrong from Colorado, very right-wing senator, Senator Helms from North Carolina, and others proposing amendment after amendment to exclude various stigmatizing conditions. And some of them went in, as you saw, like the ones about sexual minorities, but most of them were defeated. So again, universalizing. Now, not fully universalizing. The statute still, by its terms, was targeted to a particular protected class, even if it was a protected class that was understood as broad, but more universalizing, largely universalizing than the past. And when the courts read the ADA definition narrowly, right, when the courts in the lower courts in the years after the ADA was adopted, the Supreme Court in its Sutton Trilogy and Toyota opinion saying the ADA definition has to be construed strictly to create a demanding standard for qualifying as disabled, and then the lower courts following that by excluding condition after condition after condition from the ADA's definition of disability, disability rights advocates responded by getting the ADA Amendments Act passed. And that's a much bigger step even toward universalization. The ADA Amendments Act now is completely universal with regard to intentional discrimination. If an employer or anyone else discriminates against someone based on an actual or perceived physical or mental impairment, that employer is covered. And the person who's discriminated against has a right to sue to challenge the discrimination. That is a completely universalizing view of disability. Anyone can be in the disability category based purely on how their employer or a business they visit or government agency they interact with treats them. So that's completely universalizing. And even when we're not talking about perceived disabilities, even when we're talking about what are sometimes called actual or present disabilities, the definition of disability is just dramatically broadened under the ADA Amendments Act. So although it's still a protected class statute as to those cases, and particularly as to accommodation cases, it's a much broader protected class even than post-1990. So we see an effort toward a politics of universalization. That's what's going on in the effort to pass the ADA. That's what goes on later. So I want to ask, and this is sort of the last thing I'll talk about, has this changed people's attitudes about disability? Right? Because one idea of the politics of universalization is that it's going to change people's attitudes about disability. It's going to say, hey, look, here's this thing we call disability. It turns out everybody's got a little piece of this thing. Everybody's got some way that they don't match well with an institution or a physical structure that they deal with. So there's a theory there that once you press that idea, that people will understand disability is something we all have a stake in because we're all members of the disability category. Okay, so one indication of whether this has changed attitudes is that you see various advocates who were worried about being included in the disability category in the past, being willing to be included and seeking inclusion in the disability category now. So the deaf and blind groups that had some wariness, right? The NFB, which was not in favor of the ADA and now is probably the most aggressive plaintiff in the ADA space, that's an indication that at least for those groups, it's a transition that's been made. But what about outside of the class of people who have been understood historically by society as disabled or handicapped? Well, LGBT groups is interesting. So there is, of course, we live in a time of immense development in protections for LGBT individuals in American law, right? In all sorts of areas. Constitutionally, gays and lesbians getting tremendous wins in the Supreme Court on protection against discrimination in cases like Romer v. Evans, protection against being arrested for having sex in cases like Lawrence v. Texas, and protections of equal marriage in cases like Windsor and Obergefell. We also have developments under Title VII of the Civil Rights Act and Title IX of the Education Amendments providing protection to, first, transgender individuals and increasingly gay and lesbian individuals against discrimination by employers and by the schools that they attend. What about in the disability area? So there's this very interesting case that is currently being litigated in Pennsylvania, a case called Blatt versus Cabela's. Cabela's, you guys live in real America just like I do, so you probably know what Cabela's is. So my friends in the cities on the East Coast don't know what Cabela's is. Cabela's is like the LL Bean of real America. So real America, the air quotes there. So I am from St. Louis, Missouri, so I can say that. But so Cabela's hired a woman, a transgender woman, Caitlin Blatt, to do a job stocking shelves at Cabela's. They found out she was transgender and denied her access to the women's room, referred to her in the documents they used by her former name when she was a man, and made life very difficult for her. She filed a lawsuit under Title VII, under the developing theories under Title VII, but also under the ADA. Now, how the ADA, you might ask, right? Gender identity disorder is specifically excluded from coverage under the ADA. So what she said was, yeah, that's unconstitutional under all this precedent protecting gays and lesbians against discrimination, notably Romer versus Evans. What's interesting is not, individuals can file all kinds of suits. In the post-Civil Rights Act of 1991 world, right, there are plaintiff civil rights lawyers everywhere, and they'll file all kinds of suits. What's notable is the way national gay and lesbian groups have responded. So Gay and Lesbian Advocates and Defenders, which was the organization that masterminded the marriage equality strategy that led to Obergefell, actually joined in with the plaintiff to say, yeah, you know what? She should be protected under the ADA. One, let's read the gender identity disorder exclusion narrowly in the ADA so that more transgender individuals will be treated as covered by the ADA. And two, if you don't read it narrowly, it's unconstitutional. So this is very interesting. Whereas in the 1980s, you had the LGBT community fighting hard to say the disability label should not apply to us, you have now a very significant organization in the LGBT advocacy community saying, actually, we want to invoke the protections of the ADA. We want to be included within the definition of disability under the ADA. Now, that, to me, suggests a degree of destigmatization of the disability category, a normalization of disability accommodation that groups may be seeking to invoke for themselves. What about pregnancy? So pregnancy is very interesting, too. So Arlene talked about the Young case that I participated in, that I argued in the Supreme Court last year, Pregnancy Discrimination Act case. Peggy Young was a driver at UPS. She didn't get accommodated during her pregnancy. She didn't get light duty during her pregnancy. She wanted that, and she sued when she was forced to take unpaid leave. The Supreme Court ultimately ruled in her favor, and she won. And she recovered, a nice settlement at the end of the day. What's interesting, a piece of the Young case was that Peggy Young was arguing that this employer provides accommodations for individuals with disabilities under the ADA, and pregnant women should get the same accommodations as individuals with disabilities under the ADA. And a whole swath of women's rights organizations argued for the same thing, right? Women's rights organizations that, in many cases, 20 years earlier, had been arguing against accommodating disability because they were afraid, or accommodating pregnancy because they were afraid of the connotations of disability there. There's an increasing focus by many women's rights organizations in pushing for legislation that would require accommodation of pregnancy, that would be an ADA for pregnancy. Pregnant Workers Fairness Act, which is going through Congress right now, hasn't gotten anywhere, but may well get somewhere someday. A major priority of most of the women's rights organizations in Washington, including many of the ones that took a very strict equal treatment line in the past. And the many, many equivalent laws that are being passed in states and localities across the country that provide pregnancy accommodation. Even under the ADA Amendments Act, many women's rights groups that had opposed pregnancy accommodation or been not very happy about it in the past are now invoking the ADA itself to say that many pregnant women have disabilities under the ADA and should be accommodated. Again, it's a data point. It suggests that there's a degree of destigmatization, that disability accommodation is treated as a normal baseline, that the universalizing project of disability advocates may be working. Okay. Now, you've been here for an hour sitting silently, patiently, and I appreciate it. So let me just conclude by saying a couple of things. So one is, obviously, this is only a piece of the story about disability and identity and the politics of disability identity in America, whether at the time of the ADA or now. These are very complex issues. I've been trying to just pull out one strand, but I think it's a hopeful strand. I think it's a strand that suggests that the effort by disability rights advocates to make a case about what disability is, that is a universalizing case, is at least resonating in some important ways with some important folks. And I tend to like universalizing strategies. If you read my book, you see I used to take a very different position, and then I sort of decided that the politics of distinction doesn't work very well in America. And if you take the position that universalizing strategies are good, this indication that the universalizing strategy of the disability rights movement may be hopefully succeeding in some ways is a positive sign. So thank you very much for having me here. And I look forward, I'm sure we're going to have questions. I look forward to questions, comments, anything. Thanks.
Just say questions and comments. If you have a question, just grab the mic if you can and press the button before you ask the question. Thank you.
Hi, my name is Dan. I'm a third-year student at the College of Law here and at least for this week, the president of the Disability Law Society. So first, I want to say thank you for coming. Second, please find the microphone before you speak and introduce yourself so everyone in the room can know exactly who we're hearing a question from. So my question is, when we're talking about inclusivity in the disability rights movement, I think it's also important to talk about all types of people with disabilities. And so that might be a different strand than what you focused on.
Yep.
But so I'm sure you're aware of a lot of the data that's come out recently that half of the people killed by police last year were people with disabilities.
Yep.
And of course, it's not a shock that most of those were black people.
Yep.
And that black boys with disabilities are suspended at twice the rate of black boys without disabilities and 4 times the rate of white boys without disabilities. So, and that's not even to mention all the complex issues around transgender, LGBT, religious, every minority status. So, so my question is, when the disability rights movement is so filled with white men with physical disabilities, and as a white male with a physical disability, it's hypocritical, but also self-important that I make that statement. As one of those types of people who's going to be entering the disability rights field, how can we make disability rights inclusive of every person with a disability, regardless of race, religion, identity, everything, to make sure that we're covering all of those bases?
Yeah, I think that's an enormous question. So, and it touches on like a bunch of different things that are going on. So I think the intersection between disability and race is an incredibly important one in our society, and there's been a lot of advocacy around using disability law as a way of achieving racial justice that's involved collaboration between sort of traditional disability rights activists and activists who are focusing on racial justice issues. I think the only way, and so, you know, a couple of examples, school to prison pipeline issues, you know, actually, the Individuals with Disabilities Education Act provides very substantial remedies and very substantial tools for challenging that. A lot of racial justice activists hadn't really thought so much about using that. A lot of disability rights activists hadn't thought so much about the racial angle of the issue. And it's only in recent years they've really been talking to each other a lot. But in fact, I mean, if you look at the history of, in the education context, of disability advocacy in education, I mean, where does it come from? Well, one significant strand is it comes from Marian Wright Edelman and the Children's Defense Fund in the early 1970s. I might say, you know, Hillary Clinton too, but then that would be political, and this is a nonprofit organization I'm speaking to. But it's so it's always been there that there's been this connection. But you know, I mean, you're raising exactly the right question, and I think the only way, I mean, to me, the only way ever to solve these problems of making sure that these intersecting, overlapping groups take account of each other and take full account of their identities is to have people in all of these groups talking to each other and making these decisions, you know, and that for young lawyers in particular, I mean, one of the problems with lawyers, even lawyers who come from a particular group, historically, lawyers and public interest lawyers in particular have a tendency to kind of go into an advocacy situation and try to take charge. And so even among groups of people with disabilities, or even among groups of, you know, women's rights activists, the lawyers want to come in and try to take charge, and that's the wrong approach. I mean, and it doesn't always work well. It doesn't lead to the most effective outcomes, but also it leads to the silencing of important voices. So I don't know. I mean, that's the way I would think about responding to that.
So fancy in here. So, hi, I'm Diane, and I wrote down what I wanted to say or ask because I'm very tired. And if I start rambling, everyone will be very sorry. So, I loved your presentation, and I really appreciated the complexity and nuances of the different layers that you brought up. And I had a comment which begets a question, mayhap. So for me, I'm thinking about the critical intersections of some of these politics. What is often referred to as gender identity disorder benefiting from ADA coverage is less illustrative of destigmatizing of disability identities than the problem of a double bind that continues in needing people to vet their rights around psychiatric professionals in order to get insurance for things like surgeries, now often referred to as gender affirmation surgeries. Of course, many people who are trans-identified do not pursue identities that are connected to physical reclamation connected to surgery. I'm not suggesting that's the case, of course. And so the Benjamin standards of the past live on in some of the ways the ADA is being operationalized to meet the needs of people of various backgrounds who are seeking the surgeries that some folks are, not all. And so while gay and lesbian are no longer stigmatized or identified as illness categories in the Diagnostic and Statistical Manual of Mental Disorders, trans in many ways literally is still coded as such in the DSM, and I'm not just being discursive. I mean, it literally is an ICD code and still remains a DSM code. And so Judith Butler famously argues in her text, Undoing Gender, about this fraught reliance, or what is often more referred to as a forced dependence upon medicalization and psychiatrization to get access to the services and provisions around these issues. And so disability, gender, race, class certainly intersect. And I was wondering if you could comment on that. Thank you.
Yeah, I mean, so that raises a lot of really interesting questions. You know, from the perspective of this talk, I guess what I'd say is it highlights there are a couple of different aspects to the project of the disability rights movement that I'm talking about, right? And one of the projects was to demedicalize, and that's a project that's not that is clearly not fully achieved, right? And you see that in these cases where, you know, so I say we start out with this idea that it's the medical professionals who certify whether you're within a group or not. Obviously, there's a big effort among transgender individuals to challenge that. But at the same time, you have, in order to obtain rights under the ADA, but maybe under other laws too. I mean, people seeking to obtain, people in prison who are transgender who seek to obtain Eighth Amendment rights also are forced to kind of get certification from various medical professionals. It's dealt with through the rubric of deliberate indifference to serious medical needs, right? So that suggests one way in which the disability rights movement has not succeeded in its efforts to kind of universalize disability identity. So I think that's absolutely right. I mean, huge issues here. I could probably spend an hour just talking about those, but that's sort of the nub of what that's making me think right now.
Janice?
Hi, I'm Janice McDonald here at the College of Law. I just wanted to ask if you could talk about the role of intent in this effort to universalize, because it can be a very damaging thing. It certainly has been in some of the other kinds of civil rights litigation that we've been battling for years. We had hoped that, I think, when the ADA was passed and the subsequent legislation and litigation, that we would move away from a model of intent to discriminate, but yet it seems that we're back in the same place.
Yeah, so intent to discriminate as an issue, I have lots of thoughts on this too. So I've spent a lot of time actually intermittently over the last maybe 10 years engaging with folks like Eva Patterson, who are working on, trying to displace intent as the centerpiece of discrimination. And I've always, my response to that has always been sort of pragmatic, that you could think of intent in a way that is actually very capacious, and the problem is that courts and society don't. But if we could get courts and society to do that, that would be good. And I'm not sure that the doctrinal category matters. Whether you say intent isn't important, it's something else, the social meaning or the impact or whatever, or you say think about intent more broadly. Like, you could get there either way, and it's probably the same social and political change that has to get you there either way. So what that leads me to say is you have this very successful social movement getting a law passed, but not so successful social movement in changing attitudes in society. So the law gets out ahead of social attitudes. And this is one of the reasons you have a backlash against the ADA. In the context of changing the view of intent in general, again, whatever the ADA did, even if the ADA has within it, and I think it does have within it, a way to challenge the primacy of intent, it's just our politics, our society don't think of discrimination that way. And so whatever the law says, it's really hard to get beyond this idea of a narrow understanding of intent.
But
So
it
that's
seems,
sort of what I think.
It seems that the universalization idea is revolutionary in terms of the whole structure of our society and the approach, and therefore, the idea of adopting things like intent is almost counter to the idea of that revolutionary universalization.
Yeah, and so I think that I totally agree with that. And so I think that what makes the social change, the way the law can make the social change, is not so much by kind of saying this is what the requirement is, but in actually getting these practices to get adopted and be treated as normal, right? The degree to which employers now and schools now and institutions now think about issues like accommodation compared to when the ADA was passed, it's just a huge change. And I think it's that change that makes kind of accommodation feel much more normal for other groups. I think it's the same thing about the way the law changed issues of harassment. Again, we're very much a work in progress on that, very much a work in progress on that. One of my other recent kind of public intellectual pieces was about Title IX and the fight over Title IX everyone's having and harassment on campus. we're very, we're not where anybody thinks we should be. I mean, depending on what your view is, we've gone too far, we haven't gone far enough. But still, the things that were taken for granted in workplaces and in school settings, even, when I was a young lawyer, are just not at all taken for granted today. And that's in part because of the law has created a bunch of practices that have changed society. It's not so much that the law has convinced judges to say particular things are required. It's the law has empowered various people within various social institutions to create a better space. And I think that in the end then reflects back on what the judges will say. So, and I think the same kind of thing can happen here.
Thank you.
There we go. So thank you. I'm, again, Steve Kusisto, and it's a delight to hear you today. And as Diane said, such a nuanced and thoughtful presentation. Just great. So I'm wondering, though, if you might be able to speculate, which may be your least favorite thing to do, I don't know. Speculate a little bit, because I travel around the country considerably and visit lots of colleges and universities, and I've even done disability audits for colleges and universities. And as you know, and many people in this room probably also know, the Department of Justice has had considerable activity over the last few years devoted to taking colleges and universities to task through the legal system for copious failures to live up to the ADA. And I've written about this. I've written about it in the Huffington Post and other places, but I'm still struggling to figure out what it is about higher education that in some measure that is gaseous. It's a gaseous measure. Still,
There's a lot of gaseous expressions in higher education.
What is it that's singular about higher education that puts it behind in so many instances when you can find on one side of the campus a universalizing and embracing attitude toward disability, but then you can go 15 feet away and find inaccessible restrooms, a bureaucracy that doesn't care, a mentality that says, so sue us. Yeah. We'll get around to it once you sue us, right? Even here. So, and of course, Michigan's famous story about the football stadium.
Sure.
Right? So,
I know.
What is it about higher education because this is something we're all pushing against?
Yeah. So let me ask, the hypothesis is that higher education is different than anywhere else. And it may just be, so the contrary hypothesis would be, well, we just know higher education better because that's where we live. I certainly agree that, there are a lot of issues in higher education, and, there are certain dynamics of higher education institutions that make that happen. A lot of them relate to really good things, right? Faculty governance, I think, is a really good thing. But what that leads to is a lot of people saying, well, you can't impose mandates on me. Don't tell me to post my PowerPoints ahead of time so my students can review them because that's just not how I do my class. Don't tell me to take whatever steps I need, whatever steps you think I need to do to make my classes accessible. So part of it is that, right? I think that's very, so in the Title IX area, that's very much the issue, right? People just say, this is how I teach, and you can't interfere with me. And I think you do see a lot of this in the disability context. Some of it is, higher education institutions are very bureaucratic institutions, and so often you have an office that is dealing with disability issues that is part of a big bureaucracy, and they may well have good intentions, and if they have good intentions, they're still smothered, or they may not have good intentions, but there's no way to deal with them, right? So I think that's part of the issue too. I don't know. I experience the same frustrations. I will, just because of what I teach and what I write about, I get a lot of students coming to me saying, here are the issues that I'm having. I'm sure you must, right? And I think I feel lucky at the law school I teach at. We have an administration, a dean of students in particular, who really cares about disability issues and is very responsive. But I've taught at plenty of places where that's not true, and I think that's not true throughout the university I teach at. So I think this is a problem everywhere. And the only question I have is it a problem at every university, or is it a problem literally everywhere? And I don't know the answer to that. Thanks. So someone in the back, yeah.
My name is Michael Roberts. I'm a third-year law student here at SU, and my question was sort of around the same issue of societal attitudes about disability, and I was wondering your thoughts on how many civil rights movements get a lot of coverage, especially in schools and other places, and not so much with the disability rights movement. Like, it's not taught in standard education, even in up to higher education. It's not usually taught. And I was wondering, how much of an impact do you think that has?
Yeah, I mean, so I still think, as a societal matter, in our society, the consciousness of disability as a civil rights matter, and disability as an identity, is sort of somewhere behind other civil rights efforts. And actually, to go back to the point about the point about police shootings, it's really interesting that, I mean, the Black Lives Matter movement shined a very important light on, police abuse of disempowered communities. And it's really interesting that an enormous percentage of people who are the subject of police abuse are people with disabilities, who may also be black, and both things are important, or members of other racial minority groups, and both things are important. But we rarely hear about the disability angle about that. And, so when I was at the Department of Justice, so I was in the Civil Rights Division, where one of the things we were doing when I was there was starting to be aggressive in dealing with police departments that had patterns or practices of violating people's constitutional rights. And we just saw city after city where there were all these shooting incidents involving people with disabilities. And they weren't talked about as part of disability advocacy. And I think that's true about a lot of different things. And I do think it's because we don't talk about, we don't have a curriculum that talks about the disability rights movement, the civil rights movement. You take AP US history, you learn about, you don't learn very much about any civil rights movements, but you learn about the African American civil rights movement, you learn about the women's movement. You don't really learn very much about the disability civil rights movement. And there are very few, this is a place that's sort of a mecca for this kind of study, but there are a lot of places where you really, and actually University of Michigan is a little bit too, so you get that where I teach, but a lot of places you really don't. So I do think that's a big part of it. I think there's still this idea among a lot of people. Disability is complicated because disability is a status that everybody has a disability or has a person with a disability in their family. Everybody, if they live long enough, is going to have a disability, right? And that leads to this sort of weird set of, well, I feel affinity, but I also feel aversion at the same time, right? And so I think that psychological piece for a lot of people is hard too, right? And so I think it's all those things. All right. I see a hand also all the way back there, so maybe we could do two more.
I'm Dean. I'm a PhD student in the School of Education. In terms of K-12 education and the Rowley decision, it's sort of the continuing, strength of that some educational benefit standard that's held. In the age of testing No Child Left Behind and its following act that was just ratified, at the very least it seems a little bit irrelevant, if not totally beside the point in an age when outcomes are really how students are measured. Some educational benefit seems a little weak. Can you speak to that?
Well, so I agree with that. When I was at DOJ, we actually we tried to litigate that issue, basically to say Rowley is a product of the 1980s, but in the post No Child Left Behind world, some benefit is not what we should be thinking of the IDEA as requiring, and it fits the statutory text, and we got shot down in court. I mean, the court sort of rejected that view. But I do think there are a lot of efforts by advocates to push these issues in court right now, and there is, education policy has become so much more controversial lately. But I really do think there is this increasing mismatch between the idea that if you have a disability in school, all you're entitled to is just to be able to get something from school, and then what we demand in terms of excellence and achievement from every student. And so it's not a surprise, right? It's not a surprise that No Child Left Behind, incredibly controversial law, but most disability rights advocacy groups were basically supportive of it because they saw it as a lever to get people with disabilities treated as fully able to achieve. And it remains a vexed question. But I think you're exactly right in focusing on that mismatch. I don't think there's an answer to it right now except to say that people are pushing on those issues. So, over there. And do you have a microphone near you? Okay.
Okay. It's on. Hi, my name is Talana Jones. I apologize for coming in late. I was coming in from work. But 2 questions. So I was really excited to hear your talk. When I saw the title Disability Identity, I was interested in how that was going to play out and the intersections of disability identity. And I think to the last question, in the ADA class I participated in last year, I'm not a law student, I'm a School of Ed student. I was always struck by the fact that people had to ask for the accommodation. And that's what invokes the next steps, right? But if the language of disability varies, particularly if we don't talk about the intersections of race and disability, race, gender, and disability, et cetera. So not acknowledging always how other communities might talk about disability and the language of disability, particularly how they identify. So the things that are covered, that end up being covered under the law, folks might not connect them to a disability identity. And so Bell Hooks always offers this idea that marginality is a site of resistance, right? So this idea that counter to universality, right? This idea that you are over there, you are experiencing the world in this particular way. And so that means something, and it usually invokes a pushback in terms of what you're trying to seek in terms of your equality. How then do we move or shift people, I think even beyond universality, because it almost makes me think about my son who has Down syndrome, who has an intellectual disability. Sometimes it feels like I might say you learn differently, but you don't have an intellectual disability, right? Like those are two, the understanding of it and the ways in which it plays out in the world feel very different, right? And so it's a falsity almost. It's a false comparison in that moment. And we lose out then on what's actually happening for folks who have disabilities in ways that they experience oppression in a different kind of way. And so when we're looking at the protection of the ADA, where we would want to invoke it and really have people pay attention to it, almost feels like it gets lost in like the last portion of what you were sharing. And so while I was hearing it and I was taking it in, I was also struggling with it. So how do we balance that as we're talking about the hopes, right, of the ADA and how we continue to change society's thoughts about it, but at the same time, not missing out on essentially these oppressive things that are still happening for people with disabilities that you may not be able to identify with, and you really are coming from a privileged place, even though we're having conversations about how we all can connect and counteract and understand.
Yeah, I think those are great questions, and so that's why I say most of the time I'm not that optimistic. Most of the things I talk about are not very optimistic, and so I was trying to pull out an optimistic strand here. But I think those are what you're talking about are just continuing struggles of the thinking about what thinking about what's the right way to think about disability, what's the right way for everybody, with whatever kind of condition, disabled or not, how they should think about disability, and how we get to a place where we have a society that's treating everybody as if they are the people we expect to participate fully in everything we do. And, that is, like, that part of the disability rights movement is, things are a lot better here than in other countries. Things are a lot better now than they used to be. Things are a lot worse than they ought to be, right? And so I don't have anything to push back on you with, except to say, yeah, I mean, I think that's the pessimistic part of the story. Sorry. On that note, bye, everybody.
Say thank you. I have so many things I want to discuss with you now. I want to thank you so much, really, Sam, for joining us, for sharing your thoughts in a sophisticated and accessible and really interesting and charming way. So thank you so much. And I also want to thank all of you. I have to say, having speakers come and allowing us to come together to talk about and share ideas for me has been really the highlight of my year, or maybe longer here. So thank you, all of you students, faculty who come, who participate, and thank you for allowing us to have this opportunity together.
And thank you all for coming. I really appreciate it, and your great questions.